On May 5, 2022, MyPillow CEO Mike Lindell was hit with a $62.7 million federal defamation lawsuit. The case stemmed from Lindell's repeated claims that the 2020 presidential election was stolen and that Dominion voting systems executives helped manipulate the results. Dr. Eric Coomer, a former Dominion executive, accused Lindell of defamation, emotional distress, and civil conspiracy, claiming the allegations destroyed his reputation and caused severe emotional harm. Lindell's defense argued that his statements were protected political speech under the First Amendment, but because Coomer was considered a public figure, he had to prove that Lindell acted with actual malice. Then, on March 8, 2023, Lindell was finally deposed by the plaintiff's attorney, Charlie Kane. And that's where the real courtroom drama begins. Mr. Lindell maintained a combative demeanor throughout the deposition, repeatedly claiming that the defamation lawsuit was completely frivolous. Under Rule 30 of the Federal Rules of Civil Procedure, the court may impose sanctions on anyone who obstructs, delays, or frustrates a fair deposition. Because Lindell frequently avoided direct questions and responded with personal attacks, attorney Charlie Kane systematically placed objections on the record. These objections were important because they documented Lindell.
Tell us your full name, please.
Michael James Lindell.
Well, good morning, Mr. Lindell. My name is Charlie Kane. We met for the first time
Who's paying you?
About 4 minutes ago.
Okay, go.
Is that right?
What's it?
Is that right?
What was the question?
We met for the first time.
Yes.
Okay. Here's what we're going to do. We're going to start slow because the court reporter is trying to take down what you're saying, okay?
Don't sit and scold me already, mister. I'll do whatever I have to do. So you're just a lawyer. You're an ambulance chasing lawyer. So don't start with me. I got all day. I'll take as much time as you want. So let's go. You're not my boss. You're just a lawyer, frivolous lawyer. So go. Don't start scolding me.
Oh, I'm asking questions. I'm not going to scold you.
Go ahead.
So let me finish my question, okay?
Yes.
I tend to be a slow talker.
Good for you.
I'm from Texas originally.
Good for you. I got all day. We'll make a week of this. How about that? Go ahead.
Probably up to your lawyer, but I'm happy to stay as long as you'd like.
Just keep going.
All right. Why'd you call me an ambulance chaser?
What?
Why did you call me an ambulance chaser?
Because you are. This is a frivolous case, and if you're representing this guy and you've read this case, you are a disgusting lawyer. Period. That's my right to say. You want to sue me too, Mr. Ambulance Chaser? Are you working on contingency or consignment with the guy? What are you? I can't believe anybody would take this. This is absolutely disgusting. It's a disgrace to our country. It's a disgrace to you.
Anything else?
No, that's it. You asked me the question. I answered it.
All right. I said objection, non-responsive. Let me explain a few more things to you.
What?
Let me explain a few more things to you.
Mm-hmm.
Have you given a deposition before like this?
I've given a ton of depositions.
Okay, so you understand the process somewhat.
Mm-hmm. Sure do.
Okay. When I ask you a question, you need to do your best to respond only to my question.
We're going to arrest me? I'll say whatever I want, and if we have extra, that's there's no rule that says I can't give a full answer. So, I'm telling you the rules. Have you ever been in a deposition where they can't stand who you are? Have you?
A lot more than you, sir.
Okay, good. Keep going. All right. Don't tell me about my depositions. You're not my boss. You're just some frivolous lawyer in here, and you bringing this frivolous case to me, and especially against a company that had nothing to do with anything. Right. You're disgusting. Keep going.
I want you to understand another thing.
What's that?
This case is pending in federal court in Colorado.
I don't care. What does that have to do with anything?
Do you understand that?
Yes.
All right. There's a federal judge that's going to likely be reading and watching this deposition.
I don't care.
You understand that?
I don't care. She should have dismissed this a long time ago. Okay. She hasn't ruled on that. There's a problem. I got a problem with her too.
Okay. The judge has practice standards on how...
No, the judge did not dismiss this case. We put in to get it dismissed, and she ruled an unfair ruling saying, well, go ahead and do discovery and waste all your time while I'm sitting there not doing nothing. That's what that judge is doing. So don't tell me what the judge is doing, and you just let me worry about the judge reading this, okay?
I just want you to understand that.
No, you just don't worry about me. You're not out for my benefit, okay? He's out for my benefit, not you. So you can, don't worry if I say something that offends the judge, okay? You just let me worry about that. You got that?
Yeah, I got it.
Okay, good. Keep going.
The reason I bring that up, sir, is if the judge is not pleased with your conduct in this deposition, there may be penalties associated
Okay, good.
with that.
You tell her, you go ahead, and you thank you for your worrying about old Mike. You're really, that's great. It seems like you bring a frivolous case up, you really have my back. Go ahead, keep going. That judge, you put this in the record, that judge, it's a big problem I got. If someone didn't have the money or time to sit through this garbage, when I put into her summary judgment last summer and she hasn't ruled on it, either say yay or nay. It's disgusting. It's disgusting to our country that she couldn't make a ruling. Go ahead and do deposition. If it was some guy that didn't have money, you would put them under just in this garbage. Wasting my day, wasting my time. But think if it was someone on the street, don't you care about people? This is disgusting. This judge should have ruled a long time ago that you're yay or nay, frivolous or not. But she didn't. She said, go ahead and do discovery while I sit and decide what I'm going to do. That's disgusting. I got no problem with you on that. I got a problem with the judge not making a ruling. So there. Now go ahead. Now that the judge has that on record, now you don't have to worry about what me and the judge think of each other. All right?
Objection, non-responsive. Here's another thing that I need you to know, Mr. Lindell. If the court determines that you're not being responsive or acting in good faith today, we may have to come back and do this some more. And I want you to understand that.
Oh, I got that.
All right. And if that's the case, I will be asking for attorney's fees and costs for us to do it again.
I'm already asking for them. I might just come after you guys for the most frivolous case ever when this is done. If there's a way to sue you, believe me, I'm doing it.
Okay.
Okay, just so you know that, beyond anything you've ever seen. So be prepared.
I'm committed to being polite and professional.
Okay,
today.
go ahead. We're getting through that. Now you know where I sit. Let's get on with it.
Failure to provide responsive answers. Under federal deposition rules, failing to raise such objections during the deposition can limit the ability to challenge those responses later. By calmly documenting each instance of evasion, Kane created a clear record of Lindell's conduct and preserved the plaintiff's ability to seek relief from the court. His professional and disciplined approach ultimately helped establish a pattern of non-compliance that could become significant when the court considered potential sanctions and the broader outcome of the litigation. Under the legal doctrine of defamation per se, making false and unprivileged accusations of serious criminal conduct can expose a person to significant civil liability if the plaintiff proves actual malice. This means the statements were made knowing they were false or with reckless disregard for the truth. Instead of providing admissible evidence to support his claims, Mr. Lindell attempted to shift the focus by portraying himself and his company as the real victims. He claimed that MyPillow suffered tens or even hundreds of millions of dollars in financial losses because of Dr. Coomer. To avoid liability, Lindell argued that his public statements were simply reactions to the lawsuit. He also attempted to downplay his comments by claiming they were either protected rhetorical hyperbole or jokes intended to mock the opposing legal team. Under Federal Rule of Civil Procedure 30(d)(3), a deposition may only be halted or limited when it is being conducted in bad faith or in a manner that unreasonably annoys, embarrasses, or oppresses the deponent or another party. However, defending the integrity of one's employees does.
Okay. In other words, if Joe VP Box Guy says, you know what, Mr. Lindell, you shouldn't be out there talking about this and also selling this product at the same time. Maybe people could get confused.
What do you mean selling this product at the same time? I object to that dumb answer. What are you talking about? Well, I didn't go out there, melt down our machines and buy a pillow. I mean, what is wrong with you? Anything I do, that's the way that, because I'm so branded. It's like, you're branded as a frivolous lawyer. Anything you do, well, you'll be branded as that, because that's all I know about you right now. So go. I mean, I don't know what you're saying. You're trying to associate that anything I say becomes part of my pillow. That's not true. Hope you get all that.
Not sure, Mike.
Non-responsive.
No, but it's disgusting when you sit here. I'm branded as now election, not my pillow guy. It's the opposite.
Mike, we just got to slow it down.
I know, but it just pisses me off.
I understand. They understand.
So disgusting.
You don't remember my question, do you?
Yeah, the question is, do people know you as the My Pillow guy, blah, blah, blah. I just gave my answer. No, they know me over here as this guy that's trying to save our country, but because of lawfare and dirty things that Eric Coomer did on that one day, which that's when I called him out, I can't go on my stage. I can't. My company has been hurt so bad because of people like this Eric Coomer, so bad. This guy, in tens of millions of dollars, hundreds of millions of dollars.
You don't remember my question, do you?
Right there, page 36. Page 36, where I called you lawyers just as bad as him. I called you guys criminals.
You did? Yeah, using the company My Pillow to make that statement, right?
After the lawsuit, Mr. Twister, after I was sued, everything in here in your little lawsuit, other than that one little paragraph, everything I said came after he sued me. After Coomer served his papers.
We don't need to replow that, okay? I've heard you say that.
Well, then I'm just telling you. So that's what, using My Pillow. After. It's a joke. It's shoving it back in you guys' face going, oh, you think My Pillow benefited from this? Give me a break. Talk to them employees that are trying to support their families. You guys are disgusting. What else you got? It's kind of a sad day for you, isn't it, to see how bad My Pillow's sitting, and you're trying to make it look like this was some grand thing to make money. It's just sad. It really is. It's sad. This is probably the most frivolous lawsuit in the history of the United States, and I mean that. It's shameful that judge did not dismiss this last summer when it was brought up for dismissal. Shameful. Rotten, horrible lawyers like you and the media saying, oh, Mike Lindell's trying to save this country just to make money. I have lost everything I've had so far. You got it? So don't sit here because I'm not going to take this garbage you're spewing out. This is horrific what you're doing. I've said it from the start of this thing. It's disgusting. I've lost millions of dollars.
You can't bang on the table because you're...
That's what I did. Sorry, I apologize. Did it break the thing? It's disgusting. I can't believe that you're a lawyer, that you would do something like that. Don't you have a moral compass? I mean, this is bizarre. This whole thing is bizarre. That I did it to make money with promo codes? Really?
All right. Have you ever asked someone like your controller to give you a report like that just says, hey, I want to see War Room. I want to see everything.
Of course I have.
Okay, good.
Or I can do it myself. I can do it myself. Their date range, I showed you on my phone. What's wrong with you? I just showed you all the promo codes.
Let's not get combative about it.
Well, no, I'm just telling you. You're asking me something. I just showed you how I can do it.
Not give a witness the right to instruct others not to answer questions or block relevant lines of inquiry. Mr. Kane's questions about customer service calls were directly relevant to determining whether Mr. Lindell commercially benefited from his public statements, making the questioning appropriate and within the scope of discovery. Lindell appeared to take the questions personally, treating them as an attack on his company and himself. He then responded with vulgar language and personal insults toward Mr. Kane. Under federal discovery rules, shouting, profanity, and personal attacks can be grounds for court intervention and sanctions. The court may order the responsible party to cover additional legal costs, appoint a discovery referee, or require the deposition to continue under judicial supervision. Following
this data we've been talking about, is it the same data that you procured from Patrick Byrne?
I didn't purchase anything from Patrick Burns ever. I've never dealt with Patrick Burns on anything, of purchasing any data. What are you talking about? Now, where did this come from? Now you're starting to be stupid. Now you're really asking some questions. Where did you even get that I purchased any data from Patrick Burns? This is the most out left field thing I ever heard. What did you want me to say? Oh, no, I didn't purchase it. I never purchased anything or got anything from Patrick Byrne ever.
Thank you. Okay, and I'm not asking about the lumpy pillow calls.
No, they're not lumpy pillows. That's not what they call on. Okay? When you say lumpy pillows, now you're an asshole. You got that? You're an asshole, is what you are. No, he's an asshole. No, he's an ambulance chasing asshole. That's what you are. The lumpy pillows, kiss my ass. Put that in your book. No, they answer anything, any problem customer that wants to reach Mike Lindell. Those are the ones. I want to talk to Mike Lindell. I want to talk to Mike Lindell. They send them to here and they go, or they call about maybe they didn't get their pillow on time because of the FedEx or whatever. Well, we'll cover them even though it could be somebody else's fault. Nobody called because of a lumpy pillow. But good one though.
You done?
Yeah, I'm done.
What I'm saying.
Obviously, you don't have a My Pillow too. You don't, do you?
What I'm saying is, Mr. Lindell.
Asshole. What? Go ahead. No, I'm pissed.
I understand.
Yeah, go. When you're saying what?
Do you need to take a break?
No, I don't need to take a break.
All right. Here's what I'm asking you,
Your
sir.
lumpy pillow question kind of set a nerve. Because obviously, just like your question in here, Mike's in your little complaint, Mike's frivolous cyber symposium, this whole case is frivolous. You should be ashamed of yourself. But go ahead. Finish your question on this and try not to talk about, get personal and badmouth my employees or my pillows or anything like that. Go ahead.
I haven't said a single word about your employees, and I don't own one of your
You've attacked them. You've attacked them. You were part of this. You're getting paid on consignment. You get paid if they get money from my employees. Yes, you have attacked them. You personally did this with Newsmax. You, and I called it right out, the criminal lawyers and Coomer, when you guys did this to me.
Thank you.
Yeah, now you got your answer. You already knew the answer. You just was hoping there was more, I think. It sucks that you're not going to win all this money, huh? Do you feel it slipping away because you're all wrong and you realize you shouldn't have done this?
I'm not sure you understand how you're perceived.
I don't care how you think I'm perceived. Let me tell you how you're perceived. You are perceived as an ambulance. You're the reason what's wrong with this country with lawyers. You're disgraceful, is what you are. I read some of the crap in here that you wrote in your brief. It's disgusting. The lies in here, one of them says, after Mike was with Donald Trump in 2017 at a manufacturer summit, he started doing promo codes on Fox. I was doing it 10 years prior. This is a big lie. You're a lying lawyer.
The confrontation, the deposition was paused and rescheduled for the next day. Mr. Lindell accused Mr. Kane and Mr. Coomer of engaging in criminal conduct. Under the foundational principles of criminal jurisprudence, a criminal offense requires a clear violation of a penal statute consisting of both a physical act and the required culpable state of mind. Furthermore, criminal prosecutions fall exclusively within the authority of sovereign government entities, not private litigants involved in a civil proceeding. By claiming that the attorneys were committing a crime simply by filing the lawsuit, Mr. Lindell appeared to conflate a standard civil dispute with actual criminal conduct. Because Mr. Lindell repeatedly obstructed the discovery process and evaded straightforward questions, Mr. Kane formally placed on the record his intention to petition the court for additional deposition time and seek cost-shifting sanctions. Under Federal Rule of Civil Procedure 30(d)(1), the court must allow additional time when necessary to fairly examine the deponent or when the deponent or another person impedes or delays the examination. Mr. Lindell's persistent refusal to provide direct answers, his combative outbursts, and his extrajudicial attacks on the integrity of the presiding judge provided Dr. Coomer's legal team with substantial evidence to support a motion for sanctions and a court-supervised extended deposition. Following the deposition, the case proceeded to trial, and on June 16, 2020,
I had come prepared yesterday, and the record will just reflect what happened yesterday. I don't need to characterize it. But I had come prepared to show you a series of video clips, many of which you referenced interviews at CNN during the symposium, discussions on Bannon's podcast, referencing Eric Coomer. We didn't go through your discovery responses because of how yesterday went. A number of emails that I wasn't able to show you, and I am going to be asking and reserving the right to ask the court to order you to be redeposed on additional issues with additional time. And I will be seeking
And I'm going to seek taking you to court because of what you've done to my employees. Everything you said comes after you sued me. Everything I said. You're an evil, evil man. There, that's on the record. Very evil. What you've done to my employees, everything that you were going to say comes after you sued me. Everything I said, and I stand by what I said. You're an ambulance chasing lawyer, evil person. You and your Eric Coomer buddy. So you will be sued. Don't worry. And you will be sued big because I won't back down.
All right.
Anything else?
I got better things to do with my life. We're trying to save a country here, not you guys ambulance chasing lawyers trying to get money out people that had nothing to do with it. My employees, if I sat here and they sat here and looked at you guys, they'd say, how could people do this? How could anybody do this to anybody? And that's, and did I say, and you wonder why I said that, and I apologize for calling your friend a scumbag, but I'm so upset what you did, not to me, but to my employees. What you did to my employees, why would you do that? But I think what you did is horrible. We've done nothing. And you guys, and then you wonder why I sit here. How do you guys sleep at night? You obviously don't have a My Pillow. That's a fact, I mean, I just can't fathom, and that's why I'm so upset. When you know how mad I was when I came in here yesterday? You're right, I should have read this, but I've got other things going on in my life that are a lot more important than these frivolous lawsuits. And it's the most important thing to our country ever, to my children, my grandchildren, everything. That's where I'm at. So we can keep going, we'll waste an afternoon. Yes, do I think you guys and them are a traitor to our country by what you did to My Pillow? Yes. We are made in America. You guys are bizarre. What does this have to do with me? I didn't badmouth Eric Coomer. Maybe, I don't care if Newsmax did or whatever they did to him. That's their business. That's your business with Eric Coomer. I mean, what they've done to me and what they've done to our country, absolutely. I stand by that. You guys served me papers. You went against My Pillow, served My Pillow and me papers in a lawsuit. You are part of a criminal crime family as far as I'm concerned. That could be the dumbest question of the week. Do I think they played a role? Of course they did. And not only sue me for billions here, now you got to double down and do it some more. But I guess you all lawyers, the ambulance lawyers, you all need a piece of the pie. I get that. That's nice.
It's your belief that Mr. Kane and myself are criminals as well?
What you did is criminal. And not your criminals, but what you've done is criminal. What you're doing here today is criminal. Absolutely criminal. You're taking money you don't deserve. You're trying to attack people that have done nothing to you, and you're wasting my time with a frivolous lawsuit because some judge didn't look at this last summer and get rid of it and say, are you kidding me? You can't sue this guy for this because you went and attacked his company and got him so he can't go on TV. I never talked about Eric Coomer in my life until you did that to Newsmax. And then you served me papers. Everything I said after you served me papers, I stand by it. Coomer's got to be part of it, and you guys are just as criminal what you did to me. Period. That's it.
It's a criminal crime family you're describing here that Mr. Kane and I you believe are a part of. Who else is in that family? I
don't know. Maybe you run it. I don't know. Haven't checked into that. Maybe that's why you sued me, so you don't, who knows? I don't know. I said, what are they, a criminal crime family? That's what they do. When it's all tied together, you have the cover up, you got Jenna Griswold there, I put the image up for the world to see. Nobody says anything about it. Nobody talks about it. You sue and attack. When you attack somebody, a company that's never done anything to you, that's criminal. You too, it's criminal, guys. I can't get around it. What you did is terrible. It's evil, it's terrible, it's wrong. And that's it. There's things in my life that are a lot more important than frivolous lawsuits. The only one, and I'm not blaming you for the frivolous other than when you put it up, because it should have been done 9 months ago. What the judge should have looked at this and said, I'm sorry, guys, this is bizarre. Goodbye. And dumped it. And the judge didn't do that. And that's disgusting that she did not dump this.
25. Mr. Lindell was found liable for civil defamation in federal court. An 8-person Colorado jury ordered his corporate media platform, Frank Speech, to pay $2.7 million in damages to Dr. Coomer after determining that Mr. Lindell had falsely accused him of treason and manipulating the 2020 election. Although Dr. Coomer initially sought more than $60 million and later filed a motion requesting a substantial increase in the financial judgment based on Mr. Lindell's continued conduct, U.S. District Judge Nina Wong denied the request for an enhancement, noting that the jury had expressly declined to award punitive damages. Mr. Lindell continued to maintain his defiance, and his legal defense subsequently filed a motion asking the court to overturn the jury's verdict as a matter of law. On March 25, 2026, Judge Wong officially denied that motion, ruling that Lindell acted as an active promoter of the false narratives rather than merely serving as a passive broadcaster. This deposition provides a combative glimpse into the federal thorough discovery process, demonstrating how quickly standard litigation procedures can break down when a participant refuses to follow the rules of civil procedure. During a deposition, a deponent does not have the authority to dictate the terms of the examination, and holding prominent public positions does not create a special exemption from those legal obligations. Answers are expected to be direct, relevant, and responsive, rather than becoming part of a shouting match on the official record. When a deposition turns into an ideological performance instead of a fact-gathering exercise, the focus inevitably shifts away from the core merits of the case and toward the hostile conduct of the witness. As this example demonstrates, once that boundary is crossed, the consequences can extend far beyond a single deposition recording. Such conduct can contribute to multi-million-dollar defamation verdicts, judicial sanctions, and lasting damage to a party's legal credibility. Comment below if there is a case you would like us to cover. Thank you for watching, and don't forget to subscribe and share as we continue working to promote a more informed society.